The new proposed GINA rule will offer some clarity to employers in that it does now permit an employer to get from an employee's spouse who is covered under a wellness program information regarding their prior health history that would otherwise potentially have been barred by GINA, the Genetic Information Non-Discrimination Act. It also authorizes both penalties and rewards for that incentivization. What it does, however, is also creates a problem in the sense of the rules are more onerous than those formulated by the agencies that we thought should have the primary lead on Affordable Care Act enforcement, that is the Departments of Treasury and Labor and HHS. So there are both pluses and minuses there for employers with regard to wellness programs. The uncertainty comes from a number of areas. First, for example, the calculation of a benefit based on the cost of a family plan or dependent coverage plan is limited to the spouse and does not include the children, and the employee's actual contribution has to be limited to the 30% of the cost of single coverage. So there's a complicated calculation there, again, which would not be required under the Tri-Agency Affordable Care Act regulations. So that's one area. Number two, the uncertainty is the EEOC reserves the right to say that a wellness program is not okay if it doesn't, in the EEOC's estimation, promote health or prevent disease. Now, the real question there is, where does the EEOC come off with the expertise to make a determination as to what would prevent disease or promote health? Isn't that really the expertise of something like HHS? And didn't the Affordable Care Act really put that kind of a determination in federal agencies other than the EEOC? It suggests that the agency will now, in conjunction with its ADA proposal, permit a 30% benefit, that is 30% of the total cost of coverage, but with that calculation wrinkle that I already mentioned. Number two, it suggests that the agency is not going to take account of the tobacco cessation benefit under the Affordable Care Act that is permitted to be up to 50% of the cost of such activities. There's no mention again in these regulations, these proposed regulations, of that important goal that is contributed to by a 50% incentive or reward with regard to tobacco cessation. So those are a couple of the key areas. We also have to be concerned with when these regulations will be effective and what the lead time is that employers will have to incorporate any necessary changes to their programs before the effective dates or their open enrollment periods for subsequent plan years. Make absolutely sure that your wellness program design absolutely complies with the Affordable Care Act tri-agency regulations. That's going to put you in very good stead if you have to defend it against any EEOC challenge to your wellness program. So certainly do that. Secondly, I would make sure that your wellness program can't be challenged by the EEOC as, in fact, in any way seeking the disclosure of actual genetic information and thereby preventing any claim that genetic information was infecting any employment decision. And by the same token, make sure that for ADA compliance purposes, because this would surely trigger EEOC compliance activity, make sure that you are offering alternatives so that individuals with a disability will have a reasonable accommodation for being able to get any incentives that are offered under the wellness program. Those are certainly absolutely critical musts to minimize the chance of a litigation and to enhance the employer's position in the unlikely event that they are faced with litigation.